Welcome back to Morning Live. Now, while some of us have already been at it, for many, today is probably their first day back at work following the festive season. And given that we're still under lockdown, what are the legal do's and don'ts for both employers and employees? What if an employee were to do something that they deem necessary for work that gets them into trouble with lockdown regulations? What if correct safety protocols are being or not being adhered to at work? And once South Africa has vaccines available, will an employer, for example, be allowed to force you as an employee to take a vaccine or bar you if you don't? So let's discuss some of these legalities with lawyer Imraan Mohamed, who's a director in employment law at Cliffe Dekker Hofmeyr. Imraan, thanks so much for your time. Welcome to Morning Live.
Good morning, Sakina. Good morning.
So having just come out of the festive season, where many people obviously would have traveled to visit loved ones, or employees might find that they have contracted the coronavirus over this festive period, or may have been in contact with someone who has, what is the responsibility of the employer in terms of ensuring that self-quarantining is happening, especially if the worker is, say, freelance?
The obligation of an employer stems from the regulations of last year. So the regulations that had come into effect from last year, March, which provides that an employer must ensure that the biohazard, which COVID essentially has been designated, is dealt with in the workplace in a manner that avoids transmission within the workplace. So what the Alert Level 3 regulations now do is imposes further obligations upon an employer or an employer, particularly in the return to work, as it were, in 2021, in ensuring that the protocols that were in place in 2020 continue into the new year.
But how does the employer then go about ensuring that they actually adhere to these protocols? For example, Imraan, last week we had a situation at the Beitbridge border post. And following all of that, towards the end of the week, we saw the MEC for Health in Gauteng saying that all employers should actually ensure, they should make sure that people who came through the Beitbridge border post, because of the lack of controls with regard to social distancing, among others, were not adhered to at times. They should ensure that people actually do self-quarantine. How do employers go about making sure that this, in fact, does happen?
Well, a lot of it is practical tips for employers to implement. So the regulations don't specifically specify what it is that an employer is required to do, but there is an obligation upon an employer to ensure that it takes the necessary measures in order to mitigate the transmission of the virus at the workplace. So in relation to self-quarantining, an employer can very well impose an obligation upon an employee returning after the festive break to provide a disclosure to the employer as to whether or not the employee has been to a hotspot. The hotspots have been designated in the 29th of December Alert Level 3 regulation, so we know where the hotspots are. Traveling abroad has always been an obligation to disclose. So where employees have done so, they would be obliged to provide that disclosure to an employer. An employer can then very simply provide that it is a requirement prior to returning physically to the workplace, if that is going to be necessary, that there be a period of self-quarantine. And we know that that period is now changed from the initial 14-day period in 2020 to 10 days, as that time period is reduced during the period of 2020. Currently, it's 10 days. So an employee will be obliged to provide that information, and an employee that fails to provide the information or provides false information can be disciplined by an employer for that. So that's the one aspect. The second aspect is a failure to provide correct information in relation to issues related to the virus could very well be a contravention of of the very regulations and could be a criminal offence as well.
So can an employee of a company sue the employer for negligence if they are forced to come into the office and forced to be in contact with someone who has indeed disclosed false information and had contracted the virus and they became infected?
Well, it could be more than suing for negligence, because that's very time-consuming legal process. An employee who's concerned in relation to their own well-being, health and safety from a health and safety perspective, so they've got reasonable basis upon which to conclude that entering the workplace currently would expose that individual personally or other employees to the transmission of the virus at the workplace, would be well within their rights to refuse to work. And in that instance, an employee can simply say, I refuse to work. So that's the first aspect. The second aspect is if an employer is negligent and there's a transmission of the virus in the workplace, that then gives rise to an occupational health and safety claim under COIDA, which is the Compensation for Occupational Injuries and Diseases Act, where an employee may then be able to sue for benefits arising out of the transmission of the disease. And that's a process that's proceeded with through the compensation fund.
Imraan, there's also been a lot of questioning around the actual leave when someone has to quarantine. Where does that leave get deducted from? Is it annual leave? Is it sick leave? I mean, how are and should employers be dealing with this?
Well, Sakina, let's deal with the question perhaps in a more piecemeal fashion. Pre the festive season, what we were advising a lot of our clients to do was before the designation of the hotspots. So before the 29 December regulations had determined precisely where the hotspots were within the country, we looked at the situation and the potential with the increase in the number of infections, to say to clients that what they should be doing is indicating to employees who were intending to travel to areas at that point in time where it was already publicly known where infections were to increase. So there were parts of the Eastern Cape, for instance, we'd known into December that Port Elizabeth, for instance, was a massive hotspot. And that was before the designation of a hotspot in terms of the law was promulgated. So what the advice was at that point in time was for employers to indicate to employees that if you were going to travel to an area that was not designated a hotspot, Port Elizabeth is an example at that point in time, employees would then be required in January of 2021 to disclose that travel to the employer and would have to quarantine. So employees would be advised prior to the festive season that's what the requirement would be, that there would be a self-quarantine period after that period in time, and how their leave would that be allocated for that period. Fast forward to where we are currently, we now have we've now got a legal framework in relation to what constitutes the hotspots. Portions of the Western Cape, portions of the Eastern Cape, Gauteng, Northwest, Limpopo, KZN have been designated hotspots, particular magisterial districts in areas within those provinces. So now there's legal impetus in relation to what an employer can require. Employees who've returned from those hotspots, we've discussed the issue of the Bedbridge example earlier. Employers can require employees to provide a disclosure in relation to their travel to those hotspots. Employees must provide that information. And if there's been that travel, well, employees would be required to quarantine. What the regulations do not do is that it does not say that when employees return from the hotspot and are required to quarantine by the employer for 10 days, that period of 10 days are to be paid leave. It's not paid leave. An employee who works from home is obviously in a more advantageous position than an employee who would be required to work physically at a workplace, because that employee would be able to quarantine and self-isolate, as it were, from a remote area, and in that instance continue to render services and be paid for that period. An employee who can't, or who doesn't have the ability to do so, i.e. to work remotely, if that employee's annual leave has already been utilized, well, that employee then sits in a precarious position, and because there's been no services rendered, the principle in our law is no work, no pay. Then for that 10-day period of quarantine, it's obviously not a full 10-day period of work days. For the work days, the employee would then not be paid.
And
so
then
it's a long answer. So apologies, it's a long answer, but I think the logic of why you end up at that point then becomes clear.
And important. And Imraan, we have less than 2 minutes, but I have to quickly ask you, with vaccines coming into play now, can an employer institute a mandatory vaccination policy once the vaccines do become available?
Sakina, this is a complicated question, and we need more than 2 minutes to get to the grips of it. But in summary, probably the gist surrounding the imposition of a mandatory vaccine that can be summed up in 2 minutes is the following two points. The first point is what drives a mandatory vaccine would be the following. If the law does not require that the entire population be vaccinated, in other words, there isn't a law general application that says every single citizen or every single person in the country by law will be required to be vaccinated. To be vaccinated, and that's not what we see in the international trend to be either. Then it becomes an issue for particular employers to grapple with and to determine within their particular workplace whether a mandatory vaccine is to be implemented. Complicated question. The underlying impetus of that is an obligation of an employer to ensure that the workplace is safe and secure for its employees and those other individuals who visit that workplace. So that would be one of the guiding principles. If there's been high transmissions of COVID within a particular workplace, or alternatively, massive numbers of employees who have been exposed to the virus, well, there may be justification for an employer in that instance to impose a mandatory vaccine. But the principles and how to get to the question of whether or not to apply one is going to be a difficult question that individual employers on a case-by-case basis will have to grapple with. It's something that employers in trade unions, I must venture, will seriously need to start taking into account, and that's before we get to a point where government says, well, we're in a position now to start vaccinating the population. Those discussions need to start happening now.
Imraan, thanks so much for your time. So much more to be discussed, but I'm sure we will once we actually get to that point where people are vaccinated. Imraan Mohamed from Cliffe Dekker Hofmeyr discussing employment under the current adjusted level 3 regulations, as well as talking about vaccines, what happens around that once it becomes available, what some of the legalities may be. Let's take